Hearing the appeals, Warner-Lambert and generics.
My Lords, I appear for Warner-Lambert in this matter with my learned friends Lord Panic and Messrs Copeland and Austin, and my learned friends Mr Speck, Mr Saney and Miss Pickard are here for activists and Mylan. My Lord, Mr Silverleaf and Mr Saunders will be here for the Secretary of State from tomorrow. And with your Lordship's permission, the intention is for me to address you on the majority of the validity aspects, that is our appeal on plausibility and the respondent's cross-appeal on construction, and then my learned friend Lord Panic will address you on abuse and infringement. And with a following wind, I hope to sit down about 3:30 today and hand over to my learned friend Lord Panic.
And you know we're beginning slightly early and finishing early tomorrow.
Indeed. Yes. So, my Lords, the intention is that my submissions will take the following course. I'm going to start with a little bit on the technical background, then I'm going to look at the patent, then I shall turn to the way in which the insufficiency attack was raised in this case, as it's relevant both to the issue of plausibility and to the abuse appeal. Then I shall turn to the law on plausibility. I'm not going to spend time on the TRIPS point. The respondents have made it clear in their reply that they see plausibility as part of sufficiency, and we have a number of interveners who, while supporting Warner-Lambert's position generally, have not suggested that there's no role for plausibility at all. So I will focus my submissions on showing that the courts below have wrongly applied the requirement for sufficiency to the present case. I shall also deal with my learned friend's appeal on the validity of claims 10 to 12, and then I shall look at the issues of construction of the patent, and I shall then hand over to my learned friend Lord Panic to make a few additional points on the general principle of a validating construction. My Lords, I'd like to emphasise at the outset that our 3 points on appeal, while each freestanding, are all consistent with each other, and our position is either that Claim 3 should be held to be plausible on the construction reached by the courts below. Alternatively, it should be construed as limited to peripheral neuropathic pain, which would render it plausible. And if neither of these contentions are accepted, then it's in the interest of justice that the patentee should be permitted to amend in the way proposed. And our submission is that all of these approaches
they're not quite consistent, are they? In the sense that the second two arguments lead to a narrower result than the first, a narrower pattern than the first, don't they?
They do, my Lord, but they're not. The suggestion in my learned friend's reply that there's some inconsistency in our position, and we respectfully say...
Consistency in virtually all alternative arguments. That's why they're alternatives.
Indeed, indeed. But our overall submission, we say that all of the arguments are supported by the general policy considerations which I have come to, and that if the courts below and the respondents are right, then the United Kingdom is out of step with the EPO and the other signatory states to the European Patent Convention, the upshot being that a valuable and immediately workable innovation will not receive the reward that Parliament intended, and which in fact it has and does receive elsewhere in Europe and indeed the rest of the world. So with that introduction, my Lords, could I turn to the technical background? And your Lordships will see this is set out in the Court of Appeal judgment at paragraphs 9 to 14, where they précis the judge, his longer summary at paragraphs 37 to 82. And your Lordships have also got the statement of facts and issues at page 104 of the core bundle, but I would like to highlight a few additional points, if I may. Firstly, the types of pain that were known at the priority date in 1996. They are set out at paragraph 10 of the Court of Appeal judgment. And the important distinctions for the purposes of this case are, first of all, nociceptive pain, which is pain caused by heat or mechanical pressure, which stops once the source is removed. And then a subset of nociceptive pain is inflammatory pain, which occurs with swelling and leads to increased sensitivity at the site of injury. And a different type of pain is neuropathic pain, and that is pain caused by damage to the nervous system itself, which also results in increased sensitivity, and that damage can be either to the peripheral nervous system or the central nervous system, and we shall have to return to that. And as the judge recorded in paragraph 52 of his judgment, neuropathic pain is a different type of pain with a different quality. Unlike nociceptive pain, it doesn't stop when the original injury heals and can become chronic. And symptoms can vary from patient to patient, even within a single diagnostic category. And the judge also recorded that neuropathic pain is severe and debilitating, and there was a significant need in 1996 for further and better treatments for it. And the treatment of neuropathic pain provided a huge challenge to the scientific and medical profession. And this was for a number of reasons. Firstly, difficulties arose because the underlying cause of neuropathic pain were not necessarily fully understood. There was also the subjective nature of pain, which of course varies from patient to patient. And as recorded in the statement of facts at paragraph 15, this meant that the distinction between different categories of pain was neither absolute nor consistently understood. A further problem which the experts referred to at the trial was that the placebo effect when giving drugs for pain is often strong. So a patient can be given a new drug and they will report some improvement for a few weeks, but then that will wear off and they will revert to their original pain state. And this resulted, because there was no satisfactory treatment for pain in 1996, doctors would often try off-label treatment of existing drugs which had been approved for other uses. And Dr. Scadding, that's the respondent's clinical expert, explained that he did this in the period before the priority date. That's at paragraph 4.53, which is in the bundles at page 1014. So, my lords, that's pain. Next is the concept of sensitization. And I suspect that at some stage everyone in this room will have experienced peripheral sensitization, the most common example being sunburn. And if you're sunburnt and you get into a warm shower, the warm water feels hot and painful, and that is caused by locally produced mediators in the skin. And this sensation, additional sensitivity, is a form of allodynia. There's sensitivity where there wouldn't normally be sensitivity. And the other term referred to in the judgments is called hyperalgesia, and that is increased sensitivity to something which would normally hurt a little. It hurts more when you have hyperalgesia. So that's peripheral sensitization, and then there's a different type of sensitization called central sensitization. And although for central sensitization the pain feels as though it originates at the periphery, it's actually caused by a manifestation of abnormal sensory processing within the central nervous system. And again, you get allodynia, so someone with migraine will find brushing their hair to be very painful, and you also get what's known as secondary hyperalgesia with central sensitization, that is spread of the hypersensitivity beyond the area of tissue damage. And so it's common ground that neuropathic pain was characterized by secondary hyperalgesia and allodynia in the sense that these symptoms were present in the large majority of patients with neuropathic pain, and that's recorded at paragraph 25 of the Statement of Facts on page 112. And indeed, it was the case as put by the respondents to my clinical witness that it was common general knowledge in 1996 that allodynia and hyperalgesia were common features of central pain as well as of peripheral neuropathic pain. Now, my lords, it's perhaps unsurprising that the difference between hyperalgesia and allodynia is often difficult to discern in practice, as is the difference between primary hyperalgesia and secondary hyperalgesia. And the judge recorded this by reference to quotes from the textbook of pain, which was the main textbook in use in 1996, at paragraphs 198, 3 and 4 of the judgment. And if I may just explain the concept of central sensitization a little further by reference to some of the background material. If your lordships would take the appendix, please, part 2. and turn to page 995.
Do you have an MS number?
Yes, MS 995.
It is 995.
Yep.
Sorry.
And this is taken from Dr. Scadding's report. He was the clinical expert for the respondents. And your lordships will see a diagram on page 995. And hopefully, if you've got the colour version, you can see the red neurons coming in from the exterior. So if we look at the top, where it says the top of the neurons in the left-hand column, neuron 1, and you'll see temperature and pain come in, and then in the dorsal horn, in the spinal cord, you'll see there's a boundary and a junction to an additional neuron, and that is where the central sensitization occurs, and about which so much evidence was given at trial. So the peripheral sensory nerves feed into the spinal column and meet in the dorsal horn.
Right, the dorsal horn is
with,
4 from the bottom, is it? Or?
It's indicated by the dotted lines, my lord, inside the spinal cord. So that's the area of the central nervous system where the neuron comes in with the temperature and pain signal, and then it transfers into the dorsal horn. There's a boundary, and there's a better diagram of this boundary in the judgment of Mr. Justice Arnold, which I'd like to show you, which is in Core Part 3 at page 747, MS 747. And what we're looking at here is we're looking at an individual nociceptor, and in the right-hand side of the diagrams as displayed by the judge, that is the area that's inside the spinal column, as we saw in the diagram in Dr. Scadding's report. And so what you can see in the top series of diagrams, you can see in the top nociceptor and the top diagram, pain is caused, and that is transmitted along the periphery nerve into the dorsal horn and registered as pain. And in the second diagram, you can see the feather, so that's just touch, that's not painful, and that's transmitted by a different type of mechanicoreceptor, and that is just sensed as touch in the normal condition. And if your lordships look at the bottom two diagrams, this is displaying central sensitization. And in the top of those two pictures, you have the same pain input, and that is sensed as a higher degree of pain, hyperalgesia, in the dorsal horn. And then in the bottom of all the diagrams on the page, you see...
We know it's higher because it's darker.
There's a thicker, yes, there's a darker and there's a slightly thicker.
The little triangles
arrow
on the left are fire.
Yes, fire, chemicals, and sharpness, I think.
Sharpness, I see. Okay, right.
Difficult to see precisely.
All right.
And then in the bottom diagram, you have the feather, but this time, because of the central sensitization, that is sensed as pain rather than merely as touch. And that's an example of allodynia. So the mechanism is all taking place, although the signals are coming from the periphery, the mechanism and the central sensitization is taking place inside the dorsal horn. One of the experts at trial described this as a bit like a hi-fi. The dorsal horn acts as an amplifier of the pain signals being transmitted from the periphery. And when you have central sensitization, it's like having the volume on the amplifier turned up so that non-painful stimuli become painful and painful stimuli become more painful. And that's the resulting allodynia and hyperalgesia that patients experience. Now, my lords, it was common ground, what is now common ground, that central sensitization was part of the common general knowledge and contributed to both inflammatory and neuropathic pain. And as far as the neuropathic pain types are concerned, Dr. Scadding, the respondent's clinical expert, explained that the most common neuropathic pain conditions at the priority date in 1996 were diabetic peripheral neuropathy, which is a aspect of diabetes, and post-herpetic neuralgia, better known as the pain from shingles, which can be very debilitating. And he explained that these conditions affected a substantial number of patients. They were both examples of peripheral neuropathic pain. And he went on to explain that the greatest number of people with neuropathic pain have neuropathic pain of peripheral origin, and that's in the extract from his evidence at page MS 1269. And the Court of Appeal recorded Professor Wood, that was the respondent's other expert, as confirming that most types of pain, most types of neuropathic pain in 1996 involve the peripheral nervous system. And in contrast to that, neuropathic pain caused by injury to the central nervous system, such as pain caused by stroke, was much rarer. And that was evidence was given on to that effect by Professor Wolfe. And that's one of the reasons why the term neuropathic pain was used at the priority date to mean peripheral neuropathic pain only, and we'll come back to that. And it's also an explanation because of the different frequency of these two types of pain and the underlying science behind it. Common ground that central pain was not properly understood, and the only mechanism proposed to explain it was held by the judge not to be common general knowledge. That's paragraph 189 of the judge's judgment at page MS 780. So, my lords, that's all I wanted to say by way of technical background. I now wanted to show you some passages from the patent, which are obviously relevant for all aspects of my appeal. So that can be found in the core bundle, core part 3, at page MS 922. And so, my lords, if I can take you through the relevant paragraphs, both for the purpose of the plausibility appeal and the construction appeal, and then if we have to come back on construction, we can do, but at least your lordships will have already seen it. First, paragraph 1 of the patent, where the invention is first set out, and it's explained that the invention is the use of an analogue of GABA in pain therapy, and it's said that the compound exhibits analgesic stroke anti-hyperalgesic action. And as we've looked at, hyperalgesia was understood to be this additional sensitivity, so the skilled person reading this would understand that this drug was said to be an anti-hyperalgesic and to reduce such sensitivity. Paragraph 2 explains that the compound is a known agent, already known to be used for anti-seizure therapy for central nervous system disorders, and that's why this patent is called a second medical use patent, because the compound per se had already been known and investigated for other uses. Paragraph 3 sets out some of the types of pain referred to in the specification, and your lordships will see the first sentence explains that the invention is for the treatment of pain, especially for treatment of chronic pain disorders. And it goes on, such disorders include, but is not limited to, and sets out a list of pain conditions. And if your lordships could just underline from trigeminal neuralgia on line 30 to sympathetic dystrophy on line 33, those are all the conditions that would be recognised as being neuropathic pain conditions at the priority date.
Up to which point?
So the first one is trigeminal neuralgia, and the last one is reflex sympathetic dystrophy.
They're all neuropathic pain.
Those are all neuropathic pain conditions, and of course part of our case is that the skilled person would notice that there's no mention of any exclusively central pain conditions such as stroke or multiple sclerosis in this list. And while we look at paragraph 3, the evidence at trial was from Professor Wood, who was the respondent's neuroscientist expert. He explained that the list of pains in paragraph 3 was unusual, since few drugs are effective in treating both inflammatory and neuropathic pain, and as a result of this, he would be extremely excited by what the patent disclosed, and that's paragraph 122 of his first report on page MS 1065. Then the compound pregabalin is introduced by its chemical name in paragraph 4. And then if we turn over to paragraph 6, we see further reference to the pain conditions that the drug is said to treat. The patent explains the instant invention is a method of using pregabalin or a pharmaceutically acceptable salt thereof as an analgesic in the treatment of pain as listed above. And the evidence at trial was that the expert would refer back to paragraph 3 for that list. Then it goes on to say pain such as inflammatory pain, neuropathic pain, etc. are included especially. And then it says neuropathic pain is caused by injury or infection of peripheral sensory nerves. And again, there's a list of neuropathic pain conditions, but none of these are exclusively central neuropathic pain conditions. And again, there's no mention of stroke or multiple sclerosis, which were said to be the best known examples of central pain at the priority date. So that's paragraph 6. And then if we just go on to paragraph 13, please, a point which is relevant.
You do say that's a definition of neuropathic pain, effectively?
My Lord, yes, that certainly informs the skilled person as to what the patent means by
Well, it says
neuropathic
pain such as neuropathic pain. On the face of it, that's
Yes,
all neuropathic pain. And then it says neuropathic pain is caused by injury or infection of peripheral sensory nerves. On one view,
yes,
that's a definition of what it's caused by.
absolutely.
It doesn't say is caused by, among other things.
No, and that was our case on construction at trial. Now, the judge said at trial, oh, well, that's true whether you're talking about peripheral neuropathic pain or central neuropathic pain. And as a lawyer, one can see that might be said to be right. But our submission is that the skilled person reading this would understand that the patentee is confining himself to peripheral neuropathic pain. That's consistent with the list of conditions we see in paragraph 6 and paragraph 3. The skilled person would notice there's no mention of any central pain conditions. And so
why is sorry, just you have to explain to me, why is, a stroke is not caused by injury or infection of peripheral sensory nerves.
correct.
So what type of central neuropathic pain is caused by injury or infection of peripheral sensory nerves?
None of them.
None. So,
None. So that's
it was.
No, that's the difference between peripheral neuropathic pain and central neuropathic pain. You have to have an involvement of a peripheral nerve for peripheral neuropathic pain. And that, our position is that the patent is confined only to conditions that deal with peripheral neuropathic pain. Now, I accept, of course, there is wording in this paragraph, say it's non-limiting, and there's wording in paragraph 3.
It's the sentence immediately afterwards, isn't it, that,
Yes.
that is mainly relied on for the opposite view.
Yes. But, my lords, we say overall, the skilled person would understand these passages to be confined to peripheral neuropathic pain.
Well, are they
conditions.
all the things which are included, peripheral nerve trauma, herpes virus infection, etc., diabetes mellitus, so these are all involve damage to peripheral sensory nerves, do they?
Yes, yes. The only condition that my learned friends point to, I think, is at the top of column 4, they point to the vitamin deficiencies. And there was evidence, it was referred to in a list. There was no oral evidence given in relation to this. It wasn't a point raised at trial, but it's in a list in Dr. Scadding's report, and it is the case that vitamin deficiencies could be peripheral or central.
So you submit that the sentence which begins, it includes but is not limited to, is simply saying these are examples of peripheral neuropathic pain.
Yes.
But not the whole category.
Yes, my lord. That's our submission.
And the vitamin deficiencies, well, I suppose you say you know it by its friends, and if it appears in a whole list of other things which are peripheral,
yes,
it's referring to peripheral.
Yes, and there were vitamin deficiencies that were known to be peripheral, cause peripheral neuropathic pain, so that it's all consistent.
Right.
So, my lord, those are the crucial passages on construction. Paragraph 13, there's a point I'd just like to draw your attention to, if I may. At the top of column 5, just the second half of paragraph 13, the patent explains that the pharmaceutical can be used in a method for treating such disorder in mammals, including human, suffering therefrom by administering to such mammals an effective amount of the compound as described above in unit dosage form. So the patent is not limited to humans, and the claims, because of this, will be construed to cover animals as well. And this is relevant to the threshold for proving effectiveness of the claims, which the judge held was animals, not humans. So to prove this works, all you have to do is put it into animals, and I'll show you a little later on the passage in the judgment where he records that. My lords, paragraph 16 onwards introduces the rat paw formalin test.
Well, on one view of the argument, it wouldn't be good enough to show it works in some mammals. You'd have to show it works in all mammals, including human, wouldn't you? Isn't that one of the...
That's not an argument that's been run yet.
I thought that was part of the case against you, that you have to show that it works across its full width.
Yes. Well, there's no suggestion that it doesn't work
In
any other animal.
No.
But we have to come back to that. So, my lords, paragraph 16 onwards deals with the rat paw formalin test, which is the test that the judge spent a considerable amount of time hearing evidence about. And so what happens in that test is you inject formalin into the paw of the rat, and it causes immediate and then longer-term discomfort, these two phases. But if you, the patent records, if you administer pregabalin beforehand, it dose-dependently blocks irritation in the second phase of this test. And that's how it was shown to be effective in the patent. There are a number of other experiments which follow. There are 3 models tested in the patent in total. And in addition to these models, there is reference at paragraphs 22 and 23 to the Bennett and Kim tests. And these were the well-known tests for neuropathic pain at the priority date. And again, we will return to those a little bit later and the evidence on those and the findings in relation to them.
Neuropathic pain of what type?
Well,
Peripheral.
Peripheral.
It says peripheral.
Yes, the patent records that they refer to peripheral neuropathy, but the experts, when they describe them in more general terms. And that's a point that we say assists us on both plausibility and construction. Because if people were willing to talk about neuropathic pain generally, and actually they meant peripheral neuropathic pain, that obviously assists on construction. In any event, if people were happy to talk about these tests as being good tests for neuropathic pain generally, then the distinction which the judge drew between central and peripheral neuropathic pain is not a fair one, we submit, and the skilled person would see these tests and think that these tests were sufficient to prove effectiveness across the scope of the claims because of the way in which they were seen generally at the time. So, my lords, it's right that technically they only are effective to show the effect of a drug against peripheral neuropathic pain, but they were referred to more generally at the time, and we say that is of assistance to us. And in fact, if your lordships look at paragraph 29A of the statement of facts, which reflects the judgment, what's recorded there is that the Bennett test was a well-recognised model of neuropathic pain without differentiating between the types of neuropathic pain which were known at the time. My lords, paragraph 24 onwards describe the post-operative test that was applied to the rats. And just a couple of final points, if I may, on the specification in relation to that. If your lordships go to paragraph 32 of the patent, at line 11, you will see the results recorded that pregabalin dose-dependently blocked development of the allodynia response with an MED of 10 milligrams per kilogram, this blockade of the nociceptive response was maintained for 3 days by the 30 milligrams per kilogram dose of pregabalin. In contrast, morphine only prevented the development of tactile allodynia for 3 hours post-surgery. And then at paragraph 34, what the patent records is that gabapentin and pregabalin did not affect PWL, that's pore withdrawal latency, in the thermal hyperalgesia test, or tactile allodynia scores in the contralateral pore, up to the highest dose tested in any of the experiments. In contrast, morphine increased PWL of the contralateral pore in the thermal hyperalgesia test. And so, my lords, the 2 points that were explained by the experts in relation to these passages, firstly, in paragraph 32, you can see that the effect of pregabalin is much greater than the effect of morphine on the pore that has been operated on in this post-operative test, and it works for 3 days, whereas morphine only works for 3 hours. And then what paragraph 34 would tell the skilled person is that if you test not the pore that's been operated on, but if you test the opposing pore of the rat, then pregabalin doesn't affect the rat's ability to take away the pore, the good pore, when it's exposed to heat, whereas morphine effectively anesthetizes the rat completely, and so the rat will leave its good pore on a hot pad when it's given morphine, which it won't do if it's given pregabalin.
What does PWL stand for?
PWL is pore withdrawal latency.
Oh, thank you.
And what that means is the rat's pore is placed on a level which has heat applied to it, and then you measure how long it takes for the rat to take its pore away from the heat. And so obviously the quicker it takes it away, the better the response, which shows that the rat has not been generally anesthetized. And so what the experts said about this was that pregabalin was clearly doing something different and more selective than morphine. And Professor Wood, the respondent's neuroscientist expert, explained that the skilled person would understand from this that pregabalin had a very interesting and novel type of action which didn't correspond to that of known drugs. And he said it was acting as an anti-hyperalgesic rather than as an analgesic when he gave this evidence. My lords, finally, just on these tests, the patent doesn't distinguish between primary and secondary hyperalgesia, and this is a point on my learned friend's appeal. And Professor Wood, his expert, explained that it was unsurprisingly quite difficult to interrogate the rat as to whether it's experiencing primary or secondary hyperalgesia. You can ask a person, but it's much more difficult to tell from a rat which type of hyperalgesia is being experienced. My lords, the claims follow, and the relevant claims for this appeal are claims 3, which is to neuropathic pain, and then 10, 11, and 12, trigeminal neuralgia, acute herpetic and post-herpetic, and causalgia, and these are all types of peripheral neuropathic pain. Finally, my lord, on the background, the issues that aren't before you on this appeal, it's not in dispute that the use of pregabalin to treat pain was a new and inventive step in 1996, and it has solved a significant and long-standing problem in the treatment of chronic pain. Further, all of the experts agreed that they would be excited about a claim to treat the conditions in the patent. Further, it's not in dispute that pregabalin does in fact treat successfully all of the conditions set out in the patent. It's now in very widespread use in the United Kingdom and throughout the world. And although it's also authorized to treat epilepsy and generalized anxiety disorder, the majority of the prescriptions are for pain. So our submission is this patent represents a significant contribution to the welfare of patients with this chronic and otherwise intractable problem.
Including central pain.
Including central, yes. It's been approved to treat patients with central neuropathic pain. Now, my lords, I want to turn to how the attack on the claims was raised, because in our submission this highlights the error that the courts below fell into. And so I'm focusing now on the insufficiency attack which succeeded, which is the central pain point. Now, the judge sought to recount the procedural history in the abuse judgment, which you will have seen, which starts at the core, part 3, page 887. However, the Court of Appeal did not adopt all of the judge's characterisation of events, and we submit rightly so. And I'd like to make a few points, if I may, on this, which are relevant both to the plausibility case and to my learned friend Lord Panic's submissions on abuse. So if I can, start with the pleaded attack on sufficiency, and if we can go to the pleading, which is in the appendix part 2, MS 981. And so it's paragraph 2 of it doesn't matter whether we look at the activist or the Mylan, they're both the same, the pleading. This one is slightly easier to read because it hasn't got all the amendments in. So your lordships will see paragraph 2 is the classic sufficiency plea. The specification of the patent doesn't disclose the invention clearly enough and completely enough for them to be performed by a person skilled in the art, and that reflects the statutory wording, which we'll come on to. And then the particulars that are given, firstly, if your lordships would just read little a and subparagraph 1 below, please. And what I'd like to comment on this, the pleading only refers to the types of pain referred to in paragraph 3 of the patent, or as claimed in any claim. And the point I would make on that is that the pleading is expressed at the same level of generality as the specification and the claims. It doesn't go and refer to, say, stroke or multiple sclerosis. And as we've seen, central pain is not mentioned in paragraph 3 of the patent, nor is it claimed, nor any of these particular central pain conditions referred to. So, as you'll understand our submission below, and we maintain, you have to start salami slicing up the conditions mentioned in the claims to get the argument up and running in relation to central pain, and that wasn't something identified in the pleading. Consistent with this, my lords, it was accepted by Mylan and activists that the attack on central pain which succeeded wasn't even conceived of when this pleading was written, that the attack only came to Mylan and activists' attention when they received the evidence from the experts, the first rounds of evidence, and there's a witness statement, not in the bundles, which explains this, which the judge from my learned friend solicitors, which the judge and the Court of Appeal referred to. Next, my lords, if you could look at paragraph B, which is the further alternatively, it would require undue effort on the part of the skilled person to identify whether the compound was in fact effective. And we highlight here the further or alternatively, and it's the or alternatively which causes the problem in the approach which the courts below accepted, and we say does not reflect the proper application of Article 83 sufficiency. Because as the Court of Appeal recorded in paragraph 49 of their judgment, it's the argument under subparagraph A which succeeded, and the one under subparagraph B didn't. And so it mattered to the respondent's success that there was an alternatively in B and not just a further. And of course, our submission is that you have to apply the classical sufficiency test, the undue effort test referred to in B, in order to come to a conclusion that a claim is insufficient. And what the effect of the alternatively wording has done is to separate the plausibility argument away from the heading of sufficiency overall and the undue effort elements of sufficiency, which we'll come to, and that it reflects the mistake which the courts below have made in elevating this plausibility test to something pseudo-statutory, which doesn't in fact reflect what is written in Article 83 of the EPC and in the UK legislation. And of course, the point in this case is that if there was any doubt on the face of the patent, the experts agreed that it would be easy to establish that pregabalin was effective to treat neuropathic pain by carrying out the Bennett test, specifically paragraph 2, paragraph 22. So there was no undue effort imposed on the skilled person reading the patent to get it to work. The experts agreed that it wouldn't be difficult to get it to work, and in fact they would want to do so. And so if we're right, and as the respondents now appear to accept, if plausibility is just part of the overall test for insufficiency, then this alternatively wording shouldn't be there. There should be an and. They would need to have shown it was implausible and would require undue effort to establish. And on the evidence, they would have failed, and the insufficiency attack should have been rejected. And we say that's the proper approach to insufficiency, which the courts below got wrong. Finally, my lords, you'll see paragraph C. There was also a classical attack on sufficiency. It was suggested at one stage that the drug was ineffective to treat established acute postoperative pain, but that point had been dropped by the time we got to the closing trial, and therefore wasn't dealt with by the judge. Now, my lords, the procedural history of the case is summarised by the Court of Appeal in their judgment at paragraphs 48 to 62, and perhaps we can look at that briefly. It's starting at page MS 559. And the important passages for my purposes at present are paragraph 54 to 56. And perhaps your lordships would just remind yourselves of those paragraphs. It's beginning on page 560. So the points I'd like to draw from these paragraphs, if I may, the Court of Appeal recalled that the respondents didn't conceive of the point until after the exchange of evidence in chief. The point was raised for the first time by the respondent's clinical expert, Dr. Scadding, in a single paragraph in his reply just over a month before trial. No attempt was made to amend the pleading at that stage. And we note that Dr. Scadding didn't say that the claim was implausible, even though the burden was on the respondents to prove insufficiency. He just recorded that there were conditions which he were thought not to have a central sensitization component. Now, this point wasn't addressed at all by the respondent's neuroscientist expert, Professor Wood, in any of his 5 expert reports, even though the judge held that the neuroscientist would take the lead in relation to the sufficiency aspects of the case, and that's recorded in paragraph 119 of the judge's judgment. Professor Wood's reports were focused on the point that no claim to treating neuropathic pain would be plausible because the data in the patent went exclusively to inflammatory pain. In other words, he took a strict view of the nature of the data in the patent that was rejected by the judge. Now, it's said by the respondents in their case in reply, at paragraph 129, that there was no reason for them to focus on the subcategories of central and peripheral neuropathic pain any sooner, because they only needed to invalidate the broad class of neuropathic pain. My lords, that's not accepted on this side of the court, because claim 11 of the patent, if you'll recall, is to post-herpetic pain, is exclusively peripheral, and so the respondents have always had to focus on neuropathic pain caused by injury or infection to peripheral sensory nerves.
Which was the reference to the case? Which paragraph in the case was it? Respondent's case, which...
It's paragraph 129 of their reply.
Yeah.
Now, it is accepted that the point on central neuropathic pain was clearly raised in the respondent's opening skeleton exchanged just a week before trial, and that's the basis upon which the Court of Appeal went on to determine the issue, and we can see that at paragraph 182 of the Court of Appeal judgment on page MS 589. So they didn't dwell on the earlier stages in the litigation. They merely took it from the raising of the point in the skeleton a week before trial. And so, my lords, the reason for looking at the procedural background is threefold. Firstly, we say the error in principle in the way that the courts approached the pleading and dealt with plausibility is highlighted, because it comes as a standalone argument when it should have been dealt with under the heading of sufficiency. Secondly, this is all relevant to the backdrop to the abuse appeal, and it shows how unsatisfactory was the manner in which the attack on the patent, which succeeded, was raised. And I just remind your lordships, this was a speedy trial with all the normal pressures that it brings, and the hearing of the trial itself was on a very tight timetable because of the availability of the expert witnesses. And the infringement trial followed immediately on from the validity hearing. There were significant and complex arguments being run on inventive step and infringement, and this plausibility attack was only a very minor component of the respondent's original case. And we say this is relevant because at the heart of the law on plausibility lies the submission that valuable patents, such as the present, should not be invalidated on technical grounds. And we say would characterise the point which succeeded even on the findings of the courts below as a technical point. And we also make the forensic point that if the central pain objection was not apparent to the claimant's experts when they prepared their comprehensive first reports, or indeed to Professor Wood, the neuroscientist, in any of his 5 reports, then it's not a real objection which should otherwise bring down a valuable and inventive contribution. And we say if the law of plausibility and sufficiency is properly applied, then this objection should not have been upheld. And with that, I'll turn now to the next topic, which is the law on plausibility, if I may. So, my lords, the question of sufficiency is asked and answered under Article 83 of the European Patent Convention, and you can see that set out in the authorities at volume 17 tab 212, page MS 7092. So page 7092 in tab 212, you see Article 83, disclosure of the invention, at the bottom in the right-hand column. And then also relevant, because it's referred to in some of the cases, is Article 84, which is the top of the next page. The claim shall define the matter for which protection is sought. They shall be clear and concise and be supported by the description. Now, my lords, there are equivalent provisions in our domestic legislation, which can be found at tab 202 and which we've set out in the agreed statement of facts. But the domestic legislation expressly states that its provisions in this regard are intended to have the same effect as the EPC, that's section 137 of the 130 subsection 7 of the Patents Act.
Section 100?
130 subsection 7 of the Patents Act, 202. If your lordships would like to look at that, but it's page 6962 at the back of the tab. And so what 137 subsection 7 says is that certain sections of the Patents Act are framed as to have as nearly as practicable the same effects in the United Kingdom as the corresponding provisions of the European Patent Convention, and the sections for the purposes of this appeal are sections 14.3, 14.5, and 72.1 and 2, and they are framed in the same words. And so it's easier probably just to look at the words of the European Patent Convention rather than having to look at two different
Sorry, I don't see that at the moment. Where
6962 at the back of tab.
Yes, I've got it, yes.
It's section 130, subsection 7 in the top left.
Yes, right.
And there are various sections which are said.
Yes, I see.
And if your lordship goes back, you can see section 14 is on page 6946. See section 14.3 and 14.5. So 14.3 reflects Article 83, and 14.5 reflects Article 84. And then if you go on to page 6954, you will see section 72.1c, which again reflects the wording found in Article 83 in relation to sufficiency. Now, there's a minor point of interest here. Your lordships will notice that the requirements of Article 84 are not reflected in section 72, but they are reflected in section 14.5. And this reflects the approach of the European Patent Office, which is that Article 84, the clarity requirements of Article 84, are not a ground for opposition once a patent has been granted, but they may be used to prevent the patent being granted in a form which is said to be unclear at the examination stage. And so the domestic legislation has repeated Article 83 in section 72, but has only got Article 84 in section 14. Now, this has been the subject of previous argument as to whether or not the requirements for clarity are a ground which can be used to invalidate a patent once it has been granted in the United Kingdom. And your lordships in previous decisions have held that clarity can be taken into account insofar as it is a requirement that the skilled person must be enabled to make the patented product across its full width or to its full extent. And this is perhaps best reflected in the speech of my Lord Mance in the Lundbeck case, which for your lordships note, it's paragraph 51 is Lord Mance in Authorities 2, tab 20. I don't think we need to go to it. Lord Neuberger also referred to this in paragraph 81 of the same judgment, where he explained that the support requirements of section 14.5, that is the clarity aspects, take you straight back to the sufficiency requirements under section 14.3, that is to say, can the invention be carried out? So if the invention is not clear enough, then the approach we take in the United Kingdom is that it can't be carried out and can't be worked, and that's how the clarity requirements arise in an application for revocation and are dealt with that way. And there's no issue between us on this appeal that that's not the right approach. Now, my lords, the other relevant statute which we referred to, or statute, the other relevant legislative material which we referred to was the TRIPS agreement, which we don't need to turn to, but it's at tab 214 of this bundle for your lordship's reference, and it's articles 27 and 29, and 29 is in precisely the same form of words as article 83 to reflect the sufficiency requirements. And of course, the point we seek to make from all of this legislation is that none of these treaties or statutes use the word plausible anywhere in them. The wording is always the same in terms of Article 83 and the requirement that the invention is disclosed in a manner sufficiently clear and complete enough for it to be carried out by a person skilled in the art. And our submission is that this doctrine of plausibility, which has arisen in the case law, should not be permitted to adopt a life of its own, as it seems to have done in recent years. And just as a number of the interveners submit, FPIA, the ABPI, CEPA, and the BIA, the concept of plausibility should be kept in its proper place as just one relevant factor when looking at sufficiency, useful particularly in those cases where the evidence of actual workability is completely lacking, such as where there's no data in the patent at all. So we say it should be confined to these examples and shouldn't be treated as a pseudo standalone element of the statute which has to be complied with, and if it's not, the patent can be revoked. And we say that's the error, one of the errors that the courts below fell into.
Plausibility is, in the context of second use medical patents, was clearly not envisaged at the time when the convention or the statute were drafted at all. So it's arrived in there in order to deal with this problem. Is it your submission that plausibility has any role in the assessment of validity, or are you saying that it has none and it only arises as part of the officer's process of review of the original?
No, well, we don't go that far. We say it may have a role, whether it's an evidential rule, as some of the interveners suggest it should be, or whether it's a threshold, a low threshold, which may be reached by looking at the evidence.
When you say it may have a role, its role may be evidential, its role is to establish what?
Well, the policy requirements are its role is to support the assessment of sufficiency, and if something is so implausible that the skilled person wouldn't think it could be done, then they are unlikely to try to do it, and therefore even if it could be done, the requirements of Article 83 are not met because the skilled person is not put in possession of the invention at the date it was published.
The test of sufficiency in the statute, and indeed in the convention, is whether the skilled person could replicate the invention.
Yes.
Well, just put like that, it's not relevant where the invention has already been made and you're proposing a new use. All that you need to replicate the new use is to hand it to the patient and say that's for your pain. So, how does plausibility enter into the process of replicating the invention? If it doesn't, then there seem to be only two possibilities. One is that plausibility is totally irrelevant legally. The other is that it's a freestanding test.
Well,
You seem to be aiming somewhere between the two, and I'm not sure that's wholly coherent.
Well, my Lord, let me try to explain that we are, in our submission, the policy that plausibility is designed to meet is to prevent somebody sitting down in their armchair, selecting a whole new class of molecules, and then writing down every disease under the sun they can think of, and suggesting that this huge class is able to treat this huge range of diseases. And in that situation, the European Patent Office would approach it under the head of plausibility, because they would have no evidence one way or the other at the time the patent is filed, when they're having to examine it. And they would say, it's simply not plausible that this invention works, because it's just too much to claim, and there's no data to support it. And so, my Lord, we would characterize that as a conventional sufficiency analysis. Is the invention put in the hands of the skilled person at the priority date? No, because there will be so much work to have to do to work out which of the individual molecules is the best one, and then which of the numerous diseases it is said to treat, which of those it works for. And that is effectively giving the skilled person a research project which may take many years to complete. And that's why under the conventional approach, the invention cannot be worked at the priority date. So the patentee has not complied with the bargain which society requires, which is to hand society the invention in a document in return for a limited monopoly on that invention.
So do you apply a plausibility test only where you've got a patent that has a scattergun approach to the uses for which it's suitable? Or do you ask yourself how much work the patentee has done, and how do you do this?
Well, you ask yourself, how much work does the skilled person have to do to make the invention work? That's at the heart of the patent system, is you have to publish your invention and give it to other people so they can take it on and make further inventions with it.
All you have to do is hand over the bills, surely.
But that's envisaging that you have a single molecule. So we've already cut down from the extreme examples we see in the European Patent Office, where there's a whole range of molecules which are claimed. So if you narrow it down to one molecule and you claimed every disease under the sun, then it might well still be said, this is a research project to work out which of these diseases it works for and which it doesn't. And therefore, you still haven't given the invention to the skilled person in the document.
So you've got to supply, in the text of the patent, some reason to suppose that it's plausible to imagine that this works.
Well, you've got to supply, in our submission, something that provides the skilled person with the invention and the ability to carry it out. And plainly, if they have to test it on 30 different conditions to understand whether it works, that is, we would say, that's not giving them the invention, because there's still a research project to be done.
Plausibility test is surely directed not to the question whether it works, but why it works, or why it's thought likely to work.
Well, in our submission, it's part of, that's only relevant if the skilled person has difficulty in carrying out the invention, because part of their motivation for pursuing it when they read the document is relevant as to how much effort would be seen to be routine and whether they would bother pursuing it at all. So it is, going back to a question Ronald put to me a few moments ago, it is a flexible test. And it's, as can be seen in the European Patent Office, it is a flexible test. So where there's a claim to a perpetual motion machine or a cold fusion device, there is a lot more scepticism on the face of the examining division, quite rightly. And so plausibility, the patentee is expected to provide rather more evidence that that sort of invention works than an invention we say this sort of invention where you've got a single molecule and a single range of conditions under the heading neuropathic pain.
You would place the threshold at the point where the invention is obviously implausible rather than positively plausible.
Well, again, I'm not sure we would say we would go that far, but that is the approach the European Patent Office take, is to say, do I have reason to doubt this invention. And if there is reason to doubt it, they will look for evidence that it is supported. Now, and has to be a scale, which is why we say, in the end, it's more use as an evidential tool than as a threshold. And we say there's no objection to it being an evidential tool, that it's not mentioned in the statute. It's clearly part of what the court can look at when it's trying to determine whether the claim is workable and whether the patentee has fulfilled his bargain by providing the claim across its full scope. And my lord, otherwise you end up having to set a different threshold for different types of invention, and that becomes difficult in itself. And so our submission is that there is a coherent approach, which is, does it work? Is the skilled person put in possession of the invention across its scope at the priority date? Everyone agrees that that is what is required. In this case, we say, yes, it is, and the plausibility objection doesn't arise. But there are examples of cases where the skilled person is not put in possession of the invention, such as the Salk case cited from the EPO, where the Board of Appeal said it would take several years to get to the invention. And that's precisely the sort of case where there shouldn't have to be a requirement for evidence. It's just prima facie implausible. And unless you can show it does work easily, then you can't have your patent. And we say this is not that sort of case. And we end up with we've ended up in the courts below with the tail wagging the dog, and this test being applied apparently separately from the requirement that the invention works and the skilled person can do it without undue burden. And in a case where the skilled person said, yes, I can do it, I'd go and do the Bennett test and I'd see it work, and I'd be excited about trying to get it to work because this is a promising concept, then that is the worst sort of example of a patent to be invalidated on this extra statutory concept.
So just how do you say that the concept applies here? Just looking at such a material as there is in the patent, which points to it working in any context, how do you say that gives the skilled person sufficient assurance that it'll work in all contexts? I mean, the rat tests am I right, they're primarily not in relation to nociceptive pain, but the Bennett test is
yes, the rat test,
more expansive.
The findings of the court below were that the rat tests were primarily nociceptive,
yes,
but that the formalin test would also be seen by the skilled person to have central sensitization elements. The skilled person would know that central sensitization was an important factor in neuropathic pain, and therefore, because of that, they
I see. If you kill one sort of central sensitization, you kill it all.
If you deal with deal with central sensitization primarily in the nociceptive environment, it will also be expected to work for neuropathic pain. And so that was, at one level, was the experiments in the patent. Then there's the acceptance that there isn't a neuropathic pain test carried out in the patent, but there is the reference to the Bennett and Kim tests in paragraphs 22 and 23. And the evidence from the experts was that they would know how to do those tests, they'd be easy to do, they would want to go and do them because of the claims to treat neuropathic pain, and of course they would find that it would work, because it does work. And so that's the second level at which we put the case. And because of the findings of the judge that all you needed to do was to put it into animals, not humans, and I'll show you that passage a little later, that is sufficient to get to the claims. If you wanted, if you insisted on taking it further and saying, well, what about patients? Then, of course, we also rely on the evidence that doctors were happy in 1996 to give drugs that were known to treat other conditions, such as anxiety, to patients in order to try and treat their dreadfully difficult to treat pain. And just as Dr. Scadding gave gabapentin to his patients before 1996, so they would also give pregabalin to their patients once it had appeared, and they would find that that was effective to treat central pain. So we say we succeed on every level, and of course we now know it is successful to treat central pain.
Like I just said, I share Lord Sumption's difficulty in understanding how Article 83 applies to second use applications, and it may be worth your while taking us to some of the authorities that support your argument.
Yes, well, certainly one important point, and we can see this in the EPO case, is plausibility is applied across the scope of patent claims. It's not something that's confined to second medical uses by any sense, and we can see the cold fusion cases and such like. So it's not something which has arisen purely in the field of second medical uses. There are examples of it being applied to second medical uses, and indeed the Mr. Justice Neuberger's case at the application stage, a Prendergast application, that was an example where the patentee had written down a whole list of conditions which it was claimed this new drug would treat. And Mr. Justice Neuberger said there wasn't a shred of evidence that any of these conditions would be treated, and so the patent was rejected. And we say no problem with that. That was formally under section 14(5), but we say it applies equally under the head of sufficiency, because the skilled person is not given the invention. The invention is not put in their hands on the date of the publication of the patent, because there would be so much more work to do to carry it out.
Outside the field of second-use medical patents, you will normally establish the inventiveness of the invention by explaining how the skilled person would replicate it, so that one can see that the two concepts merge into one. But when it comes to second-use patents, where the invention of the compound has already happened, they do necessarily acquire a separate life, don't they?
Well, with respect, we would say no. There are plenty of similar types of claim where the invention is effectively in the idea, and until you've shown that you've had the idea and given some evidence that it works, no one else was in possession of that invention. And we give one of the older cases, the answers in our reply case. So again, there's a danger in focusing too heavily, we would say, respectfully submit, on second medical use claims. The same is true for first medical use claims. You can come up with a new molecule, and then you want to list a number of diseases that it might treat. Now, once you've come up with a molecule and disclosed it, then of course you give people the molecule, but until you've expressed in your patent the ability to treat a particular disease, no one has made that invention and no one has benefited from the invention. It may be relatively trivial to put a single molecule into a single patient to show that disease has been treated, but that doesn't take away from the value of these sorts of inventions to benefit patients generally. And so just because it's relatively straightforward to do it, as we say it is, doesn't mean you should have less protection than in a chemical patent where you've got to spend 3 days making the chemical substance in the first place. So we respectfully submit you shouldn't, just because you can write this down in a relatively short way, and it looks, with hindsight, very easy, doesn't mean that you should somehow be more reluctant to grant these sorts of patents or set a barrier at the level of plausibility when the headline test, can you do it, is the skilled person put in a position where they can do it, under Article 83 is met at the priority date. And that's, I mean, we have to look at the evidence on that, because we accept there isn't the data from the Bennett test in the patent, but the skilled person, the evidence was the skilled person could do it, would do it, and they would therefore arrive with the data that proves the treatment of neuropathic pain without undue effort, and that satisfies all the requirements that Article 83 sets out. And so there's no, in our submission, Article 83 works to deal with armchair patents without having to elevate this concept of plausibility to something which it isn't. And it is perhaps most useful as an evidential tool. In this case, the evidence is that it would work at the time, you'd be interested to do it, and the evidence, if you're allowed to take account of it, is that there's evidence since then that it's been approved and it does work, and we say you're also allowed to take into account that evidence following the approach of the EPO. So, my lords, we say in a true armchair invention, the patentee has simply not put the skilled person in possession of the invention at the priority date, and he hasn't fulfilled his bargain, and that's not this case. What, in the words of the EPO, the objective of the sufficiency test is to distinguish those applications which solve a technical problem from those which merely pose a further problem from the skilled person. The armchair patent with a huge list of diseases poses as many problems as it solves. This patent, in contrast, we say solves the problem because the skilled person is given the ingredient and told the conditions and can easily put it into effect. And that's why we say Article 83 has been satisfied. So, my lord, we say that it's well established under UK law that the skilled person may be expected to carry out routine experiments as part of the exercise of working the patent, as long as he doesn't expend undue effort in working the invention. And so a valid patent can involve a technical contribution which is not only expressly disclosed to the skilled person, but also includes that which the disclosure reasonably enables or a fortiori motivates the skilled person to do and to arrive at without having to work to resort to further invention or undue effort. And the classic statement of English law is the Court of Appeal in Mentor and Hollister, which is at Authorities tab Bundle 3, tab 33, and perhaps it's worth looking at that. Page 2529. This was a case about a catheter system, and the judgment of Lord Justice Lloyd, as he then was, if we can pick it up on page 10 of the judgment, which is page 2529 of the electronic bundle. And Lord Justice Lloyd sets out at line 42 the issue he had to determine. Perhaps your lordships would just read 42 to the end of the to line 14 on the following page.
This doesn't seem to be on the point, does it?
Well, he's asking about does the invention disclose, does the specification disclose the invention clearly enough and completely enough for it to be performed?
Yes, I mean, this is whether it can be replicated by a skilled person. But as I understand your test of plausibility, it's really whether a skilled person reading the patent would feel sufficiently encouraged or motivated to follow it up in all the areas which it covers, which seems to be a different sort of test.
Well, I should correct myself if that's the impression I've given you, my lord. We say the test that plausibility, if it's going to form part of anything, is does the specification disclose the invention clearly enough and completely enough for it to be carried out?
Well, then you get back to my Lord Sumption's point that it certainly does. All you have to do is use it.
Indeed, and that's why we say it's sufficient. We contrast this case with the cases where...
Yes, that's abolishing any additional gloss in this context. And can you find the gloss in some other authority? This doesn't...
Well, so let me just give you the passages. The passages I'd rely on as being classical sufficiency passages, can you make it work, are on page 13, from line 2 to line 26, where Lord Justice Lloyd set out the Valency test, and then on the following page it's lines 9 to line 45, and this is so you're trying to work the patent in its lines 16 to 18 on page 14. In doing so, the skilled person must seek success. He should not be required to carry out any prolonged research, inquiry, or experiment. He may need to carry out the ordinary methods of trial and error. So routine trials are okay. So if to work a patent, to get it to work, you have to carry out routine trials, that's fine. And that's an established part of English law and also European Patent Office law. So in this case, if the skilled person was left in doubt, having read the specification of the patent, as to whether it would treat neuropathic pain, carrying out the Bennett test would be routine. The skilled person would do it, as the evidence showed, and that's why Article 83 is satisfied in this case. And we contrast that with an armchair invention and indeed the Salk case or the Johns Hopkins case, where an idea was put in a patent, but the patentee was so far away from putting that idea into practice that the type of work to be carried out to put it into practice would take many years, would be characterized as a research project, and would not be routine.
But this is a submission to the effect that the plausibility test is satisfied in this particular case. It doesn't help us to determine what the plausibility test is and how it fits into the statutory scheme.
I understand that, my Lord, and I apologise if I've gone too fast. Our basic submission on the law is that there is only one test. That's Article 83. Can you get the patent to work? And as part of that analysis, you may well look, particularly where you haven't got any evidence before you, one way or the other, you may well look and ask, is it plausible? Because if it's not plausible and the patentee can't come up with a simple way of putting it into effect, then it's very unlikely it could be put into effect at the priority date. So our submission is that the only way that plausibility arises is in a situation where the skilled person is left in some doubt as to whether or not the invention can be worked. And that it's appropriate to use it in those sorts of cases to avoid armchair patents where you would be left in considerable doubt because there's no data at all. We'll come on to the application of that test to this case, but our overriding submission is there is only one test, and that is under Article 83. And for the reason that we say plausibility isn't mentioned, so you have to put it under one heading or another, and the respondents seem to accept that it is a test under Article 83 in the end, and applying that in the way we submit it should be applied does lead you to the policy results which are desirable.
Apart from Article 83, is there any other provision which effectively prevents somebody getting a patent for, in the absence of any evidence that the invention actually works?
Well, there is, my Lord, and that's the clarity or the Article 84 requirements, which I showed you earlier, because it refers to support. There needs to be support in the description for the claims.
That's a qualifying provision that amplifies what you've got to do to satisfy the other provisions.
Yes, that's we say how it should be understood. So in the Prendergast case, Mr. Justice Newberg, as he then was, rejected the application for the patent because he said, all you've done is given a molecule, list a whole different type of conditions, and there's no support in the specification for that working. And we say that if you look at Lundbeck, you look at Biogen, you can use Article 84 under the heading of Article 83 to say, well, does it actually work? And that's what my Lord Mance and Lord Newberger set out in the passages in Lundbeck, which I referred to. How you build it in, even though there's not an express requirement for support in Section 72, and Article 84 is not a ground of revocation in the European Patent Office. So that's the other way of trying to deal with it. But in the end, we say all roads come back to Article 83. Can you get it to work? And the Prendergast case can equally show it just wouldn't work without undue effort, and therefore that's why it should have been, and it was rightly rejected. So, my Lord, that's the traditional view of sufficiency and what work can you do to prove or to demonstrate that the patent has given you the invention. Routine trials are acceptable. And the other case I'd just like to take your lordships to, because it's relevant to pharmaceutical cases, is the Bristol-Myers case in Authorities Tab 1, Bundle 1, Tab 10, at page 1605. And paragraphs 19 to 21 of Lord Justice Aldous' decision there, where he was dealing with how to interpret a claim for treating X in a pharmaceutical patent, and did this require that every single patient need to be successfully treated, or was it only a requirement, those sorts of claims, for it had to be suitable for treating cancer or whatever the disease is, without the expectation that every single patient would be successfully treated. So if your lordships just look at 19 to 21.
But if that's right, how does it fit with the arguments in this case, which the courts below have accepted?
Well, in this case, treating neuropathic pain in the claim doesn't mean it has to be successful for treating all patients with all types of neuropathic pain on every occasion.
Well, that's what I was saying. I mean, that's your argument. So you basically say that this is, inconsistent with the reasoning below?
Well, it depends really how you slice up if I think what it would be said is that it's accepted you don't have to treat every patient successfully, but if there's a cohort of patients who are not successfully treated, then that's a problem, a type of patient.
Well,
that's the distinction I think that will be said against me.
Well,
Can be made.
Presumably there's some reason why some patients react well, which makes them also a cohort. So, in a sense, Lord Justice Aldous is already distinguishing between cohorts.
Indeed, and that's what we say. We say no pharmaceutical can be expected to work for every patient. And if a patent was required to meet that level, the whole pharmaceutical patent industry would disappear overnight, because no drug.
So you say, basically, in relation to the argument that pain includes both central and peripheral cause pain, you say, so what? It's good enough if it covers peripheral pain.
On the construction of the courts below, yes.
But there's a difference, isn't there, between saying that something works for cancer and discovering that it only works for 60% of cancer patients, and saying it works for cancer and pain, and discovering that it only works for cancer.
Yes, there is.
The analogy that you seem to be drawing is between a case where something works for the prescribed indication, but not for every patient, and a case where the claim covers indications for which there's no reason to suppose it works at all. And I question whether the analogy is good.
I accept the distinction your lordship puts to me, but of course in this case we say that the claim is only in general terms. It is plausible that patients will be treated with neuropathic pain with this drug, because there is the majority of patients immediately will be treated.
Yes, the majority being peripheral.
Yes.
Yes.
And so if, yes, my lord, if the claim had listed a number of different conditions and some of them it wasn't effective for and others it was, then I quite accept the point your lordship puts to me. But in this case, we say part of the understanding and we say this is entirely consistent with the approach the European Patent Office takes, you analyse it at the level at which it's expressed and the level which the specification describes. At that level, it is plausible. And we say, end of story. And it was wrong for the judge to start to subdivide this claim into cohorts of patients which the patent itself hasn't identified, and then exclude and revoke the claim on the basis of a distinction which the patent never made and which we submit the skilled person wouldn't make reading it.
You will be taking us at some stage to the case law of the European.
Yes, I'm going to come to that shortly, Mold. Just one final point before I do. I've mentioned a couple of times that the standard which the judge found we had to hit to make the claim plausible, based on that passage that we looked at that referred to the treatment of mammals. And if we can just look at how he dealt with it in the judgment, it's in the judge's judgment, Core Part 3, page 795 of the bundles. Core 3, page 795, and the paragraphs 253 to 255 of the judgment. Just to put this into context, your lordships might wonder, why am I suggesting that you need to put it into humans to get it, show it works, when it's be easier for me on this appeal to say it can go into animals? Of course, there was the obviousness side of the case, and it was a smaller target for obviousness purposes to say you've got to show it's actually effective in humans than showing it's effective in animals. But the judge didn't accept that. He said, no, the standard is you have to show its effect, all you have to do is show it's effective in animals. So that was the test for the purposes of obviousness, which had to be met, which the respondents failed on.
I mean, testing on humans would come at stage 3.
It would, yes. Well, it would come at stage, you give it to humans in stage 1 and stage 2, and then you only test efficacy in stage 3. But the judge and the Court of Appeal both seem to lose sight of the fact that all you need to do is to put it into an animal to show it works. And that, of course, was the evidence. So the point about, well, if you could also treat off-label if you wanted to, doesn't really arise, because on the basis of the findings below, all that had to be shown was that this was effective in an animal. And of course we say that's an easier target for sufficiency purposes and one that was met. So, my lords, if we turn, that's the domestic approach to sufficiency. If we turn now to the requirements in the European Patent Office, and of course we submit that it's permissible under Article 31 of the Vienna Convention to take into account how the EPO applies Article 83 and indeed other signatory countries, and of course there's guidance from this court that we should follow the European Patent Office when we can. And so
on the basis that the EPO decisions are essentially part of the contractual mechanism for refining the concepts in the convention. I mean, on what basis do you say that the Vienna Convention justifies looking at decisions made afterwards? You may well be right, but I'd just like to follow why.
Well, because in order for us to implement the same standard, it's right that we look at how other courts and other institutions such as the EPO are also applying that.
This is Vienna Convention Article 31, is it?
Yes.
Can it be said to be, when you set up a court, can it be said to be evidence of state practice? In the state practice through the mechanism of the court which they've set up?
Yes, I'm not sure what the state is.
Yes, I see, yes. You
For
mean,
example, of the EPO. I mean, obviously, we have cases from other European countries applying the same legislative provisions, which we say are also supportive.
You have a treaty with an adjudicative mechanism within it. Then without needing to go to the Vienna Convention, you can say that what the adjudicative mechanism produces is part of the treaty. It's part of the agreed mechanism by which its meaning is to be established.
Yes, I mean, maybe we don't need to look at Vienna at all. We can just...
the EPO is set up under some form of treaty, isn't it?
It is,
To
yes.
which the EU countries and other countries are party.
Yes.
So that
It's not a European...
So it is a substantial body, looking at it in those terms, of state practice. In a way.
Yes.
Right.
But we also have the guidance from activists and Lilly, Schutz and Werrett. We should be looking at the way the EPO applies these laws, as the German Supreme Court, the German courts, the French courts, and that's, we say, is all helpful. Anyway.
Where do we find the provision that constitutes and authorises the EPO to do what it does?
I'm not sure that's in the bundles, my lord. Let me see if I can dig that out over the German, if that will be helpful.
So 137 have the same effects as the other territories.
Yes. We'll come back to that. So, my lord, in the EPO, the standard applied, and we see repeated in the cases, is that any alleged insufficiency requires there to be serious doubt about the workability of the invention, substantiated by verifiable facts. That's the standard we see. And, of course, as I've referred to already, part of the problem the EPO faces is that it is a granting authority, and so it's often faced with specifications at the earliest stages of the life of a patent, when there's not yet any later evidence to show whether the claimed invention works or not. And indeed, at these early stages, it may be the only party before the examiner is the patentee, and there are no opponents putting in opposite views to the division. So it can be difficult for the authority to determine at that stage whether an invention can in fact be carried out. And as I've also referred to, it may be some of the more outlandish types of patent are before the office, such as to perpetual motion machines, and it's particularly difficult to demonstrate that those sorts of inventions don't work in the face of a patentee who says, oh no, I have broken the mould here, I've done something different that no one else has ever done before. And so it's clear from this that the concept of plausibility is by no means confined to second medical use cases, and we refute the respondent's suggestion that it's some sort of concession to pharmaceutical patentees to avoid the cost of clinical trials. It's far more broadly applied by the EPO in relation to all sorts of other claims.
Not surely to avoid the cost of clinical trials, but to avoid the disclosure.
Indeed, yes, that's right. That's right, my lord.
So can we look at some, what's your best EPO authority then?
Yes, I was going to come to that. I can come to that right now, or I can do it in...
I'll take it in your ordinary course.
If you don't mind.
As long as you're well within your time, are you?
I'm doing all right. Yes, thank you, my lord.
Good.
Well, as far as time, anyway. So, my lord, it's clear from the EPO authorities there's no requirement for a patent to provide data at all. And so the notion of plausibility has grown up as a substitute for actual evidence of workability, an evidential tool, as SEPA characterise it. And we say it would be wrong, therefore, for it to be given too much weight or to apply a higher standard than for classical sufficiency, where the case law is clear that you don't need to embody you don't need to enable every embodiment of the claim, because you might not enable inventive improvements at the date the patent is granted. It's clearly a flexible test, as the EPO has emphasised in a number of cases, and it only applies where there's a prima facie reason to doubt the technical effect, as the EPO cases show, and it therefore allows the European Patent Office to refuse a perpetual motion machine without experiments that sort of invention doesn't work. It allows them to reject claims to vast number of molecules, all having the same technical effect, otherwise unjustifiable monopolization of large number of molecules which don't work could be taken by the patentee. Another class of cases where we see it applied is the identification of a receptor or a molecule which binds to a receptor, where the question of plausibility turns on whether the receptor has the claimed biological effect. These are the so-called superfamily cases like Lilly and HGS and the Johns Hopkins case. And in these cases, there may be a question as to whether the monopoly is justified if the technical effect of binding to the receptor has not yet been properly identified, and therefore the invention cannot be easily worked. And we say the same problem doesn't arise in cases of second medical use claims for a single molecule, as here, because it is straightforward to put such inventions into work. And we emphasize the importance of second medical use claims, both to the pharmaceutical industry and to patients, particularly in the cancer field. For example, thalidomide, originally used notoriously for morning sickness, is now approved to treat multiple myeloma and epilepsy. So a lot of valuable drugs or valuable treatments are the subject of second medical use patents. And your lordships will understand the incredible cost and work involved in trying to develop a first medical use patent and a second medical use patent. One of the interveners, the ABPI, estimates that only 1 in 5,000 drug candidates go on to gain marketing approval, and it takes on average 12 years and over £1 billion to develop a successful new drug. There's therefore a huge incentive, because there's the benefit to both industry and patients, to encourage second medical uses to come through because of the reduced development costs and the reduced time to market that a second medical use drug can have once it's shown in the primary trials to be safe. So we say it's important that this further research is encouraged by providing patents to cover it without placing unreasonable barriers to obtain such patents in the way. And as a number of the interveners allude to and the respondents acknowledge, and as we referred, any clinical trials carried out to test a drug will become public, and so the patent has to be filed before the clinical trials are carried out. And this, of course, puts the patentee in a bind. If they can't know that the drug will be successful to treat every subcondition in any particular disease category until the trials are completed, but at the same time they have to file the patent before the trials take place, what are they to do? And we would respectfully submit that if the plausibility doctrine is wrongly applied, the patentee is at risk of losing its monopoly altogether if it turns out that the claims it filed before the trials were carried out are not 100% accurate, as SEPA points out in its intervention.
Tell me, why is it that all clinical trials have to be published?
Well, they're published on a clinical trials website, clinicaltrials.gov.
There's a requirement,
It's a requirement. It's for health and safety reasons. It's for patients, so patients can...
it's statutory requirement, is it, or is it...
I don't know the answer.
They get published.
It's a practice that's followed both in Europe and in the United States.
Designed to avoid tendentious selection of results. You disclose simply the ones that work and not the 99 others that don't.
Indeed. And you have to publish your trials before you carry them out. So it's not that you can wait until you know whether it works or not before publishing. And so even telling people that you're trying a drug for pain, one can see that could be used against you for an obviousness argument, and that's why the patent has to be filed before the trial is even started.
Right.
And of course, if there's no common general knowledge understanding of every aspect of the condition, we submit it would be wrong for a patentee's educated guess to go unrewarded and for there to be no protection available and therefore no incentive to research these conditions, but we submit that's the effect of the judgments below if the standard is maintained. And further, the approach below ignores the fact that there may be post-published data to support the successful treatment of the outstanding subconditions. And if there is such data, we submitted ought to be taken into account. After all, a patentee can lose his or her patent even if it's plausible, if later data shows that it doesn't work. So if it does work, why shouldn't the patentee be able to rely on evidence to demonstrate that, even if it's generated after the event? And the effect of the judgments below is that the patentee is put in a sort of double jeopardy position because he can't use data to show it does work after the event in a case such as the present. And I'd like to show you, before we go on to the European cases fully, just one final domestic judgment demonstrating this approach, and that's the Court of Appeal in Generics and Yeda, which is in Authorities Volume 2, tab 21. And it's electronic bundle, page 1987. And the effect of this, just before I ask you to read certain passages, the effect of this judgment was to show that later evidence was admissible to prove that a patent was implausible. And what the Court of Appeal did in this case was to overrule the trial judge, Mr. Justice Arnold, because he had said that later evidence wasn't admissible to prove the implausibility of a patent. And we submit that this shows...
Which paragraph is it?
So if your Lordship pick it up, firstly, paragraphs 50 and 51,
Yeah.
And your Lordship will see the issue.
Was this a case where at the priority date it looked plausible?
Yes. And then there was evidence later to show it was implausible.
Right.
And the judge said, you can see that just at the bottom of page 1987, his view was the last three lines. In my view, it would be bizarre if, as counsel for Mylan submitted, a patent which at the time it was applied for disclosed what everyone thought was a good invention could be revoked 20 years later because subsequent advances in science had revealed that, in fact, the invention didn't solve the technical problem.
What good does it do at all if it doesn't solve the technical problem?
Indeed.
But I mean, this.
Well, why shouldn't you revoke it then? I mean, I don't.
Quite, my Lord. We say the Court of Appeal was right in this case to say that later evidence was admissible and should be taken into account in order to revoke a patent which, in fact, was implausible. And of course, we say precisely the same approach should be adopted in a case if there's a question about plausibility and there is later evidence that it is plausible, then the same approach should apply. Otherwise, the patentee is treated unfairly.
So this would suggest that you could challenge a patent at an early stage with a result that would be completely different from the one that would obtain when you challenged it at a later stage. I mean, on the face of it, a patent is either valid or it's not.
Yes.
It's rather difficult to grapple with the concept that it's valid in 2000 but not in 2020.
Yes, which is why, my Lord, we say that in the end, the sufficiency test is the right one. Does it work? That's the question. In this case, there was evidence to show it didn't work at the priority date that was only available some years later. So your Lordship, we respectfully agree with your Lordship. The question is, did it work at the priority date? Everyone had to guess at the time it was granted because nobody quite knew. If there's later evidence comes to light that shows it didn't work at the priority date, that evidence is admissible and should be used to revoke the patent. Equally, if there's a question as to whether it worked at the priority date, later evidence shows it did, then that is also admissible, and we say should rightfully have been admitted in this case to show that the patent did work for central pain, would have worked for central pain at the priority date, and that's a reason why the claim 3 shouldn't have been revoked on the judge's construction.
What is the distinction between the gentleman you described earlier as the undesirable armchair thinker and the person you've just recently been referring to as making an educated guess?
Well, the educated guess is the level at which the European Patent Office says is good enough to satisfy this plausibility requirement.
The educated guess is because it's not purely theoretical.
Yes.
It has some foundation.
Yes.
And, well, I
But
come back.
you've got to disclose what it
Yes.
is that makes your educated guess a good one.
Or it
potentially a
may
good
be that there are common general knowledge methods to show it works, and the European Patent Office is clear that that is also allowable. And
But here, what here you'd be saying, it definitely works in respect of nociceptive pain.
there's reason to think it would work. For
There's some reason to think that, unlike other drugs, it'll work in relation to neuropathic pain.
Yes, that's what the judge found.
Yeah.
And then if you were in any doubt, you go ahead and put it in the Bennett model,
Yeah.
and you'd show it worked.
Yeah.
And if you were any further doubt, you'd take it on and do an off-label treatment, like as people were used to doing at the time.
Sort of, sort of unfamiliar prima facie case, is it? It's not even really prima facie. It's a sort of informed hunch case.
Yes, educated guess is
Yes.
one of the terms used, and we say
Is
plainly.
it's actually used somewhere, is it?
It is. It's used in the EPO cases and also referred to by.
But I think we need to see more of the cases.
Yes. Sorry, I'm coming to those, my lord.
Yeah.
But if the rule is that the plausibility has to be demonstrated in the patent itself, I can't see how knowledge that came into being 20 years later can bear on the matter one way or the other.
Well, it allows you to show what would have happened if someone had tried it at the time.
Well, if the reason why there's reason to think it works is explained in the patent, I can see the argument which says that 20 years later it may be conclusively proved that that was a good reason. But if there isn't a reason given at all, the mere fact that 20 years later a good reason turns up isn't going to make the slightest difference, is it?
Well, that is the approach that the European Patent Office takes, and that may be a fair approach. That's not this case, of course. We say there's not a complete absence of data, far from it in this case, and it's clear that the European Patent Office, the standard is not that it has to be all written in the patent. You can also use the common general knowledge. So if it was known that you could do this test and the test wasn't even referred to, then that might well be good enough if it was part of the common general knowledge of the skilled person at the time.
Forgive my ignorance, but the European Patent Office in this context means what sort of persons? They're lawyers from all over Europe. Who are they quasi-judicial or judicial?
Well, that's an interesting question, which the German Supreme Court or the German Constitutional Court are currently thinking about in relation to the issue of the Unitary Patents Court. But as far as we're concerned, my lord, we're looking at decisions of the technical boards of appeal,
Yes.
which are a separate judicial body.
They have judges from
Yes,
all over Europe.
they do.
Including no doubt
judges.
British. Yes.
Yes. And there is the examining division. The examiner also sits on the opposition division. So there is a question as to whether decisions at the opposition level are truly judicial. But certainly the boards of appeal, which are the cases that we're looking at in the bundles, are a separate body, and they've now been moved out.
What you're relying on is the TBA decisions.
Yes.
Both
So, my lords, I'm conscious of the time. The additional points to take from...
We've got a few more minutes. I think that clock is slightly fast.
The additional points to take from generics, paragraph 52, it's really the reasoning of the Court of Appeal as to why it would be right to admit this evidence. Paragraph 52, first sentence, in general, you should accept evidence if it's relevant. Paragraph 53, if you're adopting the problem and solution approach, which is the approach the European Patent Office adopts to determining questions of obviousness, then if you have provided a solution, that's relevant and admissible. 54, this is the question about whether or not the monopoly has been justified by the contribution to the art. That is an important question, and if monopoly could be justified by reference to an alleged contribution which could be demonstrated not to exist, then that ought to be before the court. And we say vice versa. If the effect can be demonstrated to exist, in fact, then that's something that the court should take into account. We say the same, 55. Thirdly, if all that the patentee has contributed is a plausible but untrue prediction, that is the very antithesis of a contribution. equally, if you have made a true prediction, that's something the court should take into account. I think 56 onwards repeats that those reasons are repeated and expanded upon. And of course, we do rely on paragraph 61 and 62. There is no general principle that all the evidence which is admitted on the issue of obviousness must be evidence which was available at the priority date. Secondary evidence can be, and often is, taken into account, subsequent commercial success, and therefore we say it is right for the court to admit evidence of effectiveness, even if that evidence is only generated after the event. We say that just as you should be able to refute an allegation that the patent works with evidence from some years later, so too you should be able to support if there's a challenge made to whether it would work at the priority date with evidence later acquired.
Who is this? Whose judgment is it?
This is Lord Justice Floyd. Lord Justice Floyd overturning Mr. Justice Arnold, so it's the same judges as in this case. We say they didn't go quite far enough in not dealing with the Johns Hopkins point and whether evidence of workability can be admitted after the event. So, my lords, based on this judgment, we say plausibility, all this points to plausibility being just an evidential factor to take into account as part of the sufficiency analysis. If it's a threshold, it's only a low threshold to be applied to the claim at the level at which it's expressed. You just need to require something in the patent to make it plausible that in this case pregabalin could be effective in any animal model in the present case. And we submit that you shouldn't use plausibility as an excuse to go behind the words of the claim and start looking for subgroups of patients who might be more difficult to treat. There will always be more difficult to treat patients in any pharmaceutical case. And if that was a bar to patentability, then no patents in this field would ever be granted. So, my lords, I'm now going to turn to the Court of Appeal decision where they review the EPO authorities, and perhaps this is an appropriate moment to break, and then we'll look at those.
We'll look forward to your resuming our submissions at 2 o'clock.
I'm grateful.